too expensive. Yeah. This is case number 21-156744. This is Universal Collections LLC versus Annette Rogers. The matter is before the court, actually set on for a motion hearing on today's date. For Universal Collections, your appearance at this time, please.
Good morning, Your Honor. Najat Francis on behalf of Plaintiff's Attorney of Record.
All right, thank you, counsel, and good morning to you. I'm looking now for Annette Rogers, or counsel for Annette Rogers. If you're on the Zoom, please say something at this time. Ms. Rogers, living at an address on Littlefield in the city of Detroit. Matter set on at 9:30 this morning. All right, counsel, so update me. Have you spoken with anybody representing Ms. Rogers or Ms. Rogers at all regarding this matter?
No, Your Honor, and this is the second time they have filed this motion. It was just heard back on October 5th.
All right, listen,
It
I
looks
see.
like someone just logged on.
I am in versus Annette Rogers. Counsel, your appearance for Ms. Rogers, please.
Oh, good morning, Judge. Attorney Brian Muad appearing on behalf of Ms. Rogers. Sorry, Judge, for my tardiness. I had 3 other matters up, believe it or not, by Zoom in circuit court, all at the same time between 9 and 9:30, and I'm sorry for that.
Thank you, Mr. Muad. Indicate your P number for the record, if you will.
Sure, Judge. P41209.
All right, and Ms. Francis, you previously indicated your appearance on this record, ma'am. And I know that this is defendant's motion to quash in lieu of answer regarding this matter. And Ms. Muad, you may at this time regarding your motion, you may proceed, sir.
Thank you, Judge. We had filed this motion on the basis that it appears from looking at the pleadings that the plaintiff's process server, in fact, alleged that he had served my client by personal service, but in fact, it turned out to be someone else that was served with the summons and complaint and did not put it in my client's hands. Also, if in fact there was a certified summons and complaint sent to my client, I don't see that there was a green card, and therefore there's no proof that it was either done by way of personal service or by certified mail. So we would ask that the service in this matter be quashed.
All right, Ms. Francis, you may proceed at this time, ma'am, and respond.
Thank you, Judge. Judge, we have attached, or the court should have the proof of service in this matter. It does show personal service to the defendant. Thereafter, we did file our defendant failed to answer, and so then we did file our judgment, which was entered August 5th, 2021. So the court rules do state that defendant could file a motion to set this aside within 21 days since there was personal service. However, defendant did not do so. That time has passed. Defendant also has not stated a meritorious defense to the lawsuit. So, Your Honor, defendant does not meet the requirements under the court rules to set aside this judgment now.
All right, so I do see the affidavit filed by the process server indicating that they served Rogers on the 1st of July of 2021. So that seems to be a contested issue. But Counselor, you indicate that there was a judgment entered subsequent to that time?
Yes, Your Honor, on August 5th, 2021.
Just one moment, let me just search that out. Yeah, All right, I do that. I am seeing default judgment entered on that date. And I'm looking at the motion that was filed in October.
There was a previous motion filed also where no one appeared, Your Honor, and Your Honor, I appeared and you denied their motion previously, Your Honor.
All right, I see that would have been in September sometime.
It may have been, I don't know if that was filed by me. I don't think it was. Maybe it was the client, but Judge, this is not a motion to, to withdraw or try to get the default judgment set aside. This is in lieu of the fact that prior to that step, we have a situation where my client wasn't properly served, and therefore the affidavit of meritorious defense, I don't believe becomes an issue in this matter, because that's not the context of our motion, is to set aside. Go ahead. Sorry.
Under the appropriate rule, I think the issue is being raised here is that the judgment is being attacked, and that attack is rooted in a lack of service. I have an affidavit establishing that service in the file. So when you say with a summary statement in your motion that that defendant was not properly served, the APN says that the defendant was served.
I would ask the court, Your Honor, that we conduct an evidentiary hearing for her process server to positively identify Ms. Rogers as the person that he placed the summons and complaint in hands of.
All right.
Judge, I would argue that our response, according to Barclay versus Crown Building, the summons and complaint does not need to be placed directly into the defendant's hands. It has to be in their, the court found that the defendant was aware someone was trying to serve them and left the papers within their physical control. The defendant was personally served in this matter, and her address, we have attached the postal verification that was her address at that time. She did have knowledge of this. The defendant's motion actually states that it was not placed in her hands, and states that the summons and complaint were not necessarily served on her. These are very vague and just vague allegations, Your Honor. This motion doesn't meet any requirements to set aside this judgment or quash the service. They haven't provided any affidavit from defendant. And Your Honor, the prior motion was filed by the opposing counsel. It's the exact same motion, just the date was changed when they did not appear at the last hearing. So we would also request that.
Go ahead. Sorry.
Well, it seems when the motion is rooted in a lack of service, at least initially, it does not require a motion to set aside default supported by a showing of good cause on meritorious defense, because the heart of the motion addresses or challenges the jurisdiction of the court or the person. The problem here, one of the problems here, is that the motion is not supported by an affidavit, whereas the process served is supported by an affidavit. But I will allow that, notwithstanding the claim that there was not in-hand service, the question here is whether or not there was a proper service. And notwithstanding there not being an affidavit challenging, which is significant here, I will go ahead and set an evidentiary hearing on that issue to see whether or not the process server in fact served this person. And while I review the case that has been cited herein, I believe that there is voluminous case law that makes clear that there does not have to be in-hand service, if you will, in order for service to be effectuated. But that's a secondary issue. The primary issue seems to be here, whether or not the defendant was served. So I'll set an evidentiary hearing and order that the process server be presented to the court and that the proper inquiry be made regarding whether service of process was completed in this matter. So I'm going to set a date for that hearing. I'm going to set it in December so we get to this year. I see in the file where the court did grant the petition for entry of default judgment. And for some reason, I'm not seeing a copy of the judgment. I'm not seeing the judgment file. So, Madam Counsel, you indicated that you do in fact have a copy of the judgment.
I don't have it in this file, Judge, but obviously I'm just covering for this hearing. So I will check with the attorney of record if they have the judgment and they can email it over to the court.
Yeah, I guess the concern, it seems to me that what may have been happening is that papers have been crossing over each other at the same time. And that the court did in fact note on its register of action that a judgment was in fact entered. But I don't see, as it normally jump out to me, I don't see a judgment. Well, maybe I'm finding something now. I'm looking all the way through the file as I'm talking. Okay, let me see what's going on. All right, I do now see, I do now see a judgment that was entered, and that was in August 5th of 2021 in the sum of $5,036.71. All right, so so we are dealing with a post judgment attack. That is what the significant issue is in this case. So let me set a hearing for December. We'll do it the 15th.
You only have those few days till you're full, like 8 cases. You want to add it on each day?
Give me the easiest day to do it on in that week.
Well, all your days are the same. You can try the 21st. You want to try the 21st? And that's all you ain't got.
All right, we're gonna put it on the 21st then, and I'll conduct an evidentiary hearing on this issue of service. The status quo is therefore maintained in this case, and I'll review the challenge under the motion at that time. That's going to be at 9:45 on the 21st of December 21st.
Thank you.
Evidentiary.
Thank you,
All right,
Judge. And you know, Judge, just for the sake of the matter, I'll talk to plaintiff and see if we can do something to avoid this next appearance. So it's a collection issue, so we'll see if we can do something about it.
That's what it. I was going to mention that. It sounds like there is a lot of effort that may be channeled in a direction different from where.
Right. Exactly. I agree. Thank you.
Yeah, so you might be able to do some good just in time for Christmas. So
well, and judicial economy too. I know, because we're going to come back, I assume, Judge, for a housekeeping question, come back on Zoom for the evidentiary hearing. Is that correct?
absolutely.
Oh, thank you,
You'll
Judge.
get a written notice in that regard. So good day.
You too, Your Honor. Have a good day. Thank you. Take care, Ms. Francis.
Thank you, Judge.
Okay.
All right, the court now calls case number 20-156640. This is Affiliated Diagnostics of Oakland versus City of Detroit. The matter is before the court, set on for a settlement conference. It appears that the parties were working on something, I think, and we'll see where we are. For Affiliated Diagnostics, your appearance at this time, please.
Your Honor, if I may, I can do my appearance for defendant, City of Detroit, Attorney Toy Thomas, P number 82295. I believe plaintiff's counsel is not appearing today because we have settled this matter. The only issue was we were not able to get their consent to do a stip in order to dismiss at this time. But right now we're just waiting for that to transpire, and this should be off your docket.
All right, thank you. Good morning to you, Mr. Thomas.
Good morning.
Now, is this one of those matters that require city council approval of anything along those lines?
Yeah, it does, and we actually have city council approval. We're just waiting for a plaintiff to give us the release back signed.
Very well. So what I'm going to do, I have a particular order that I do. I'm going to sign an order of this case, conditional upon the settlement being completed, dispersed, and it will have the right of reinstatement if anything falls apart. The case will be dismissed by order of this court based upon the good faith, I believe, by the parties that the matter is on. Get that email from.
No, that sounds great, Your Honor. Is that something that we could expect to receive through the mail or through email?
I can get it emailed to you today. Let's see if I've got your, I've got somebody else on this file. That was
You may have a Sarah.
Yeah, I have Sarah on this file.
Oh, yeah, she's actually on maternity leave. So if I can give you my email,
Yes.
it is TOI dot last name Thomas at DetroitMI.gov.
Gotcha. And I'll
Thank
get that
you.
to you. Ms. Thomas, all right? Good seeing you.
Same here. Have a great day.
Yeah. This is case number 21-151398. This is Genesis Recovery Services versus Chantel Taylor. Now, the matter is before the court. Looks like this is set on for objections to a garnishment. Just one moment. You were looking for this, right?
Hmm.
You were looking for that.
Oh, okay, oh, yeah.
It's over here.
Okay.
All right. So I do have the file in front of me. So counsel for Genesis, your appearance at this time, please.
Good morning, Your Honor. Michael Beach, BEACH, P45459 for the plaintiff.
All right. Thank you, Mr. Beach, and good morning to you, sir. And do I have Chantel Thomas on the Zoom? Say something if you're here, ma'am.
Chantel Taylor, yes, Your Honor, I'm here. Good morning.
All right, thank you, Ms. Taylor, and good morning to you, ma'am. All right, I see that you filed objections to the writ of garnishment. That's a garnishment that's directed at Coleman Hospital. Is that where you work?
Yes, sir. I currently work at Beaumont Hospital. I put in the objection to garnishment because I'm already being garnished for something right now. I'm having a difficult time just handling that. I'm not getting paid. I'm like almost on eviction status because my checks are being garnished. So I wanted to see if I can try to work something out with Genesis Recovery Center as a payment plan. That would be something a little bit better for me, considering the fact that I'm a single mom and I'm in nursing school right now. And then I never was served the documentation to even, come to court to properly have the court appearance for it. I was never given the documentation for the garnishment.
All right. Well, you know what, the garnishment would in fact be sent to Beaumont, and Beaumont, that would just pop up through your employment. But you have brought it properly before the court because you filed your objections and presented it here. Now, has there been any funds that have been taken out of your pay on this garnishment?
As of right now, no, they're basically in line because of the first garnishment, and the first garnishment is not going to stop for a long time because of the amount of it. So I'm going to court for that as well. So.
About that 6 times. I know you got other garnishment situations that you're dealing with. I was just asking about whether or not there had in fact been any funds under this particular garnishment. I also saw where you filed with the court a motion to set aside the default judgment that was entered in this case, and that judgment was entered in June of this year for some $2,650.49. And you said that there was no personal service of the complainant. But I have an affidavit in the file where a Jason Morrison, a process server, indicated that they served the documents at the address on Littlefield on May 4th of 2021.
That's not my address, Your Honor.
Okay, so you were not there or living at that address on the 4th of May?
No, Your Honor, I have no reconciliation with Littlefield. That's not my address.
Okay, thank you, ma'am. All right, so Council, on this issue regarding and let me ask you a second question. Just one second. I'll come to Mr. Beach. Let me just ask you whether or not, what is your defense to the underlying plan? Are you saying that this is not your debt, that you don't owe the debt, or what are you raising as a defense to this?
No, I was raising that I was never given the fair chance to come to court for the documentation. So the documentation that was served to that address that you speak of, that's not my address. I was never given that.
No, I'm not asking you that question because we already established that one.
Okay.
Assuming for sake of argument that you're properly before the court, what defense do you have to that underlying plan?
Well,
Go ahead. You understand what I'm asking?
I think I do. If I think I know what you're asking, I don't know who Genesis Recovery Services is.
All right. Thank you. All right, Council, you may at this time, sir.
Yeah, Your Honor, as to the motion to set aside the default judgment, we never got notice of that for today. Only notice we received is the notice on the objection to the garnishment, and we filed a response to that. But you know, this is the first I'm hearing of the motion to set aside the default judgment. Is there an indication in the file when that was sent out?
Well, I don't have any of that information. I do have where that motion was filed. The likelihood is that it was not served on you if you didn't get it. But we can remedy that. But that motion simply raises the issue and challenge that the complaint was not served on the defendant, that she did not receive due process notice. I do have a copy of the affidavit wherein the the process server, Jason Morrison, indicates under affidavit that he served a Chantel Taylor at the 15427 Littlefield address, that he did so about 11:55 a.m. He indicates that he served a black female. He indicates about 140 pounds, in the 20s, a female. Looks like he says a height of about 5'4". Yeah, it says height 5'4", weight 140, mid-20s, female.
Yeah, Your Honor, that Littlefield address, it's possible she doesn't live there anymore. That was the address that she used when she entered into the contract. That was a
Right.
Littlefield address, because that's where looks like that's where the items were delivered to, was a Littlefield address.
That's incorrect.
So I don't know, she could have moved out after that, but that's our knowledge, that was her address.
All right, did you live at that address on a previous occasion?
I never lived at that address.
All right, you never received any items at that address?
No, Your Honor, I didn't. And from hearing what you said earlier, 5'4", I'm 5'10", and I weigh 210 pounds.
Okay. All right. So counsel, let's see.
Well, now I'm truly confused, unless there's two Chantel Taylors, I guess.
All right.
I don't know, I guess I don't know if I can just ask her a quick question. Did you ever purchase any or lease to own any like queen mattress and mattress set from Romeo and Juliet Furniture?
No, I never had a contract with Romeo and Juliet Furniture.
Well, it would have been with the contract was with You Own, who's like a lease to purchase company. They finance lease to purchases with, you know, other small retailers. Okay, so you never lived at Littlefield Street.
No,
You know, let me ask you one last question. I don't know if you want to share it or not. I have the last 4 digits of a social security number that's related to this account. If it's not you, you can either confirm it or say it is or isn't. But the last 4 digits on the social for this account are 8113. Is that not you?
That is my social security. Is that what you're asking me?
Yeah, that's the last 4 of your social.
That's the last word of my social.
Thank you.
Okay.
I think that when you started out, you were talking about trying to work some out here. So did you have any connection with you on lease of a mattress or something along those lines, ma'am?
I had a mattress delivered 2 years ago from you on.
Gotcha. Very well, ma'am. Just one second. All right. So it seems to me that council, it seems to me that in this situation that that service has not been properly effectuated. What is your address currently?
My address currently?
Yes.
I live in Southfield, Michigan.
Okay, thank you. And how long have you lived at the Southfield address, ma'am?
I lived here for about 2 years going on.
So I'm looking at the you own agreement for the property, the mattress, queen set, and so on and so forth. And it has the address of 15427 Littlefield. So do you have a driver's license with you, ma'am?
Yes, Your Honor, I can show you if you would like.
No.
Okay, can you give me 1 second to just grab it, please?
Yeah, go ahead.
Sorry, child. This is my driver's license.
Before you put it up, ma'am, if you will, I want you to put your fingers over the, I want you to put your fingers over your license number.
License number.
So block that. I need you to block that.
Gotcha.
All right,
Okay, it's
now,
blocked.
yeah, if you can hold that up to me, let me just take a look at it. All right, and let the record reflect that it shows a height of 5'10", and it shows an address in Southfield, Michigan. All right, thank you, ma'am. You can remove that. One more thing, cover that for me again, ma'am, that number, and put it up one more time for me. Okay, so move your finger down for just a moment. I'm looking for the issue date. The issue date, the record should reflect is, you're gonna have to go a little bit higher for the issue date. Let me see the top part.
If I show the top part, it's gonna show my number.
That's all right, just slip up just a little bit up, 9/20, 9/29/21. That's the issue date on the driver's license.
I had to renew my license.
Yeah, you just recently renewed it, correct?
Mhm.
Well, okay, council, anything, and I know we're on YouTube, so I didn't want to expose too much information, but I need to see those particular items.
Okay.
Yeah,
So,
Your Honor.
go ahead, sir.
Yeah, obviously I wasn't prepared to speak to these issues, so I'm just trying to do a little investigation on my end while Your Honor's been questioning. But if you look at the complaint, we attached the delivery receipt. And signed for by Chantel Taylor, And I'm just comparing, and I'm not a writing expert, but she's sort of got a distinct writing style, especially as to her last name, where she takes the pen and just circles around and crosses the T on her last name. So on the delivery receipt, and then I compare that to the signature on the objection to Garn that I do have, it seems to be the same signature. So I'm at a loss here, you know, and delivery receipts indicating it was delivered to the Littlefield Street address. Do you have any, do you have any contact, or is that address completely unknown to you, ma'am?
Am I subject to answer the question?
I'm just trying to figure out what happened here.
I'm just trying to be funny, but if he was saying that this is on YouTube, it's just like,
Let me put it to you straightforwardly. You've had some contact with Littlefield in the past, correct, ma'am?
That's not my address. That's my mother's address.
Okay, very well. That answers your question right here. I got you. All right.
That's what I'm trying to figure out is, I want to know, there's some random address or actually was some type of relationship.
Not a problem. And I understand that Ms. Taylor is asserting any defenses that she may have in this regard. The problem here is that her driver's license says that she's 5'10", and the service, the process server very clearly put on the document that she's 5'4". That they couldn't have served the same person. That is too wide of a disparity. She's indicated also that her weight is substantially more than 1/4, and so it looks like someone may have received a document there, someone, a family member, etc. But certainly, just facially, it would appear that she was not the person that was served, and that's a critical issue in this case.
And I don't disagree with that, Your Honor. I do definitely, based on what I'm seeing, I agree that there's a good chance he wasn't served.
Yeah. And so that affects a number of things here. The issue becomes whether or not the parties can reach some accord on the underlying issue and submit to the jurisdiction of the court to try to resolve this, or whether you have to go back and start the service and move forward accordingly. There are a couple of ways to do this. At this point, I'm convinced that of a couple of things. That this, on the surface, it appears that this debt or obligation may very well be Ms. Taylor's obligation. The second part of this is that it appears that the service of process was served at the address, but not to the person. And the affidavit seems to make that very clear. That would mean then that the judgment will be set aside. And I suppose that what the plaintiff would do is request an extension or request for the issuance of a new summons to give opportunity to serve the proper person. Another way that this could be done is for the parties to talk about this and see if the defendant wants to stipulate and submit to the jurisdiction of the court for purposes of resolving the case. The defendant does not have to do that. But obviously, if the numbers are right and you know that this is coming back because they have 6 years to enforce that contract. If the numbers are right, maybe you could violate without going through the legal nuances of doing it. So before I make my ruling, sir, just stand tight. I'm in the middle of the case now. So before I make my determination this matter, I'm going to put the two of you in a breakout room just to see whether or not you can resolve it. And if you can, then you do it. If you can't resolve it, then I will make decisions as to what happens next. Sometimes it's better to have certainty of the direction that you're going as opposed to not knowing what's going to happen next. And Nobody's hand is forcing this. I'm already convinced that the service was not done properly because they thought they had the right person, they didn't have the right person. This case still has 3 years or so where the plaintiff could serve a complaint and go forward with trying to collect. And so maybe you can reach a compromise and figure out a way to settle this without it being in court and getting it done. So I'm gonna put you in breakout, talk about it, you don't have to fuss, fight, argue it, and then come back in and I'll make a decision as to what happens. There's a notification. Thank you. Now, who do I have there? Officer Green, who was that?
Yes. Hello?
And Judge Ford's court.
I think you should be in Judge Ford's courtroom. This is,
Okay. What is that number? Because it has 336. What is Judge Ford's courtroom number, please?
Yeah, this used to be her courtroom. That's why that confusion is there. So hers is
335. 335. 335.
Oh, 335. I'm sorry, 335.
Okay, thank you.
And also, good day to you.
You too.
Chatted her that earlier. I don't know why she was still there. I told her earlier. Yeah, I was trying to see, what you trying to find out on those, like what happened to them, what they want to answer? Oh, no, I did not see, oh, it came from, which part sent it to me herself too, I thought, what's her name, Liz? Oh, okay, I thought she did, okay, I thought she did that too, okay. All right, yeah, I seen them, I printed it out, whatever, I printed it out. Not really. I mean, it is, but no. No. Oh, well, they know it. They know it. They know it. Huh? No, I don't know you on the phone. No. Yeah. Okay, bye. Hello. Mm-hmm. Yeah, what you doing? All right. I mean, I don't care. Right there. Yes, yes. All right. Yeah, I'll be right back.
I'm good here.
All right, welcome back, Mr. Beach. Welcome back, Mr. Taylor. And I hope nobody felt any constraints or anything or during that time. It's just a way to try to at least talk about it and see if you have a way of going forward there. So go ahead and update me, Council.
Your Honor, we would just, I have no objection if the court just sets it aside the default and dismisses the case without prejudice. We'll just go refile in Southfield.
All right, very well. In that case, given the lack of personal service in this matter, I will set aside the default that would quash the writ of garnishment, and this case will be dismissed. Right?
Yeah. Your Honor, one thing I would ask though, we didn't get a copy of the motion to set aside, and on the copy of the objection to garnishment, the date or the address for Ms. Taylor was obscured. Do you have a current address for her on the court record?
I do not have an address on either of the documents that she's filed with the court. She has been very careful to not include that address, as she's perfectly prone to do so. Her address is set forth on her driver's license, so there's a way to discover it.
Okay.
All right. So
Thank you, Your Honor.
Have a good day to both of you.
Thank you, you too.